Tom's going to teach us all about the viability. So let's get started. Welcome, everybody. Excited to have you in class today. My name is Kari Sotner. I'm the Chief Learning Officer here at the National Constitution Center. And today's class is all about amending the Constitution, adding an amendment to the Constitution, editing it, changing it. That is all part of Article 5 of the original or structural Constitution. And we're going to dig into its past, its history, and some amazing stories along the way. And to do all that and teach us all about the process, and not just to trust the process, but to know the process, we are here with Tom Donnelly, who is our Senior Fellow of Constitutional Studies at the National Constitution Center. And I believe, Tom, that is the first time I've ever gotten your title right. So Tom, let us know kind of the big idea and how excited you are to get into class today.
I am very excited to get into this. I mean, because it really gets to our commitment as a nation to constitutional reform and experimentation. And the amendment process, Article 5, touches on so many important points in American history. I can't wait to talk through them.
And I think that's such a good point that, it all starts with the fact that in that original Constitution, there's a way to change it. And so that really leads to all of the questions that we have in class today. Why did they put that in there in the first place? A way to change it? How do we actually change it? And then not just the theory on how it's changed, how has it been changed over time? So as we always do at the Constitution Center, we begin with looking at the Constitution. So walk us through it, Tom. Unpack this extremely, as you always call it, a wall of text here.
Yes, it's an intimidating wall of text. I mean, it really boils down to sort of one big theme for the founding generation, which is that they really didn't believe they had a monopoly on constitutional wisdom. They didn't think that they knew everything. Furthermore, they had faith in us, that over time we would learn from how the Constitution worked and that we could figure out ways to make it work better. And so they wrote in the Constitution a formal process for changing it. And so we have it here in Article 5 of the Constitution. The big principle here in a certain sense is that they wanted it to be possible to change the Constitution, but they wanted it to be difficult. They wanted any new idea to have to attract the broad support of the American people before it could change our Constitution, because they really did see a value in constitutional stability. They didn't just simply want us changing our framework of government all the time. They thought it was important to have basic rules in place that we could all just treat as settled so we can get on with the task of governing what they would hope would become a really great nation. But at the same time, like I said, they wanted to also make this the possibility of constitutional reform a live possibility, one that we as future generations could take on both as a possibility, but also as a duty. So if we really dig into the mechanics of the process itself, this wall of text really translates into two big phases. So we break it down as a proposal phase. So this is the phase where an amendment is formally proposed, and then a ratification phase, which is that phase where we, the people, say yes or no to that idea. Both of these phases actually take a really broad, they require broad support before we could succeed as constitutional reformers. So if we're constitutional reformers, we're trying to put in place the 28th Amendment. What are the two steps of the process? First, we have to translate our amendment into a formal proposal. That happens in one of two ways. The way that every amendment in the Constitution so far, the 27 that we've added to the Constitution, they've gone through this first proposal phase. They've gone to Congress. And if we go to Congress with our proposed 28th Amendment, we have to get the support of 2/3 of the House of Representatives and 2/3 of the United States Senate. That's the amount of support we need in Congress for our 28th Amendment to become a formal proposal that we send to the states for ratification or approval. So that's one step. That's one way in which we can get our amendment proposed. That is how all 27 amendments to the Constitution have been proposed to the states. But there is another step put in here. There's another option. And that's that if Congress doesn't want to act, we can then go to the states and say, state legislatures, we want you to call on Congress to call a new constitutional convention for proposing amendments. And so the way we do this is we go to the states with our 28th Amendment, and then we ask the state legislatures to formally call for a convention. If 2/3 of the state legislatures do so, then Congress must call a new convention for proposing amendments. And so that's sort of that alternative phase. We've never used this before. It's never come to this new convention, but it actually has served an important purpose over time. A famous example is the 17th Amendment requiring the direct election of senators under the original Constitution. The state legislatures chose our senators. With the 17th Amendment ratified in the early 20th century, we then made it the system we have today, where we elect our senators directly. That grew out of a push by the states to call for a new convention. Eventually, so many states supported this, we almost called a new convention. At that point in time, finally, the US Senate relented and Congress approved of the 17th Amendment, and it went to the states for ratification. But that's the proposal phase, the first step, either Congress or the states. Once that happens, though, we're not done. Our amendment is not yet part of the Constitution. The proposal then is sent to the states for ratification. This is the process of saying yes or no to this formal proposal. And in the end, it goes to a series of decisions that have to be made by the states. Congress gets to decide the mode of ratification. It could either go through the state legislatures or through specially called state ratifying conventions. But the threshold here, again, is really, really high. Our 28th Amendment only becomes part of the Constitution if it's approved by 3/4 of the states. So that's proposal, ratification, in each case requiring a supermajority vote, broad-based support before our 28th Amendment really becomes the 28th Amendment.
And that's a little over 37 states. Like, I think it's just about 37, 38 states would have to be able to kind of move that forward. That is a lot. I love the story time when you talked about the 17th Amendment and voting for senators, and that it almost like pushing the Senate to do something. They're like, no, you're not going to do it. Okay, well, we're going to take it back into our hands. So, and I know you've talked about this before, but this idea that you can see that it's not an easy process, but it's a process where people are involved, where the states have power, the federal government has power, but it really does give a way to change the Constitution back to the people. So does it fall and rely on the idea that the popular sovereignty is an important part of changing the Constitution?
Absolutely. It's absolutely based on that core constitutional principle, popular sovereignty, which is, just think of what's popular sovereignty? Think of the beginning of the Constitution. We, the people. It's the idea that our Constitution, it's establishes a government, it's driven by us, not a monarch, not the elite, but by us, the American people. And so Article 5 is this really, really cool process that allows us to say, this, whether it's Congress, whether it's the Supreme Court, whether it's any of our officials in government, it allows us to lay claim to our Constitution and say, no, no, no. We think there's a new right that needs to be in there. We think there's a new protection that must be in there. We think the structure has to change in a certain way. It gives us a formal way for us to take back our Constitution. And if we can get the support of enough of our fellow citizens, actually get that written into the Constitution itself.
And yeah, that's such an empowering thing. And sometimes we're so quick to say, okay, federal government, Congress people, senators, you have to do something for us. We also have the power of us as a collective, and not to forget that. And you can see it so clearly spelled out in this process. So much fun kind of diving into it. But now getting back to that, getting us as a collective and getting, all the system and this entire process to work isn't easy. And it's an intense process, extremely intense process, probably more intense than almost any other country out there about how they amend the Constitution. But I guess what's interesting about it, we still have done it 27 times. So it's not easy. It's not meant to be easy. And it can be really difficult to align all of these players together to make this process work all the way through. But can you give us kind of some of the big moments in time and lessons learned from those big moments in time, and what was the special sauce in each one of those moments that made that trigger happen to make that constitutional change occur? And let me be honest, I know it's not just like, poof, a big thing happens and click, something changes. There's only a few amendments that can say that happened that quickly. Some of them take a really long time.
Yeah, absolutely. So, there are some key themes that show up over time if you look at these amendments together. Curry has them here on the screen. We'll quickly tick through them. One big theme is that sometimes amendments arise out of critics of the Constitution. So these are key reformers who look at the Constitution as written and says, it's not good enough, that there are things that the Constitution has to do that it doesn't do right now. And so the classic example here is our beloved Bill of Rights. Those first 10 amendments to the Constitution that enshrine many of our most cherished liberties, free speech, religious liberty, a right to a jury trial, all of those sorts of things, that grew in part out of the push by the Anti-Federalists during the battle over the ratification of the Constitution itself. The Anti-Federalists opposed the new Constitution. Part of the reason they opposed the new Constitution is because the Constitution didn't include a Bill of Rights. And so the Bill of Rights itself, it's one of the things that happens in the first Congress. It's the first Congress. What do they place on the agenda? One of the things is to create this Bill of Rights, these first 10 amendments designed to respond to the criticisms of the Anti-Federalists. So that's one big thing, big theme is sort of like amendments arising from critics of the Constitution. Another one is amendments arising out of historical events. And so here we think of the big example being the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. We the people ratified them after the Civil War, and they were a response to the Civil War itself, that bloody war of secession, but a lot of the lessons we learned from the America that existed prior to the Civil War, an America that had the institution of slavery. And so what we attempted to do with the Reconstruction Amendments was learn from that experience, learn from the Civil War, and try to create better constitutional baselines for post-Civil War America. And so we ratified this series of 3 transformational amendments. The 13th Amendment, ratified in 1865, abolishes slavery. The 14th Amendment, ratified in 1868, writes the Declaration of Independence's promise of freedom and equality into the Constitution. And the 15th Amendment, ratified in 1870, promises to ban racial discrimination in voting. So this is a reminder that sometimes when we amend the Constitution, we do really, really, really big things. These are big ideas that changed America forever.
It's unbelievably huge. And I feel like we will circle back to these a million times in this class and in every class, but they, like you said, they really changed the process of the entire system and the power structure as well. And Tom, as we go through these, we're actually going to look at the amendments too and think about, and you've taught this before, and I love when you teach about like, what's the weight of the amendment and what do these different types of amendments do? Do they put big values and ideas into the Constitution? Or are they almost, and I don't mean to minimize them, but are they like clerical errors that are in the Constitution and this amendment is finally fixing that issue that's just not working in there?
Yeah, no, we'll definitely keep that in mind as we talk about these different amendments. Some of them are big ideas. Some of them change the structure of the Constitution in ways big and small.
And then so the next kind of grouping that we'll dive into is around the 19th and 24th Amendment and looking at how social movements have gotten that energy to get through that process along the way.
Absolutely. So this is one of the other things. How do you build broad support for your new amendment? Well, you have a powerful social movement, one that can really lead to change in America. Sometimes it even comes before the amendment itself. And so we see examples here with the women's suffrage movement, leading to the 19th Amendment, which banned sex discrimination in voting. This was decades upon decades upon decades upon decades at work at both the national level and at the state level, eventually culminating in this powerful new protection for women at the ballot box. And then the other example here is the 24th Amendment, which ended poll tax in federal elections. This in part grew out of the civil rights movement. And so it was part of the attack on Jim Crow and discrimination against African Americans.
Fantastic. And now one of my other favorite categories is lessons learned. And sometimes I think I put the clerical errors in this category too. It's like they're lessons learned and now you need to fix something.
Yeah, so I mean, these are just a few of the examples. So the first one is the 22nd Amendment. So this gives us effectively term limits for the presidency. It's a response to FDR winning re-election 3 separate times. He had 4 separate terms in office. And so we said, you know, at the end of that, we love you, FDR, but we don't want this to happen with other people. And in part, what this was doing was reestablishing a precedent set by America's first president, George Washington. George Washington was elected, ran for re-election, and then voluntarily left office. So allowed for the peaceful transition of power. Not even George Washington could serve as president for life. And so we, with the 22nd Amendment, tried to put that back in place, saying a president can serve for 2 terms. With the 12th Amendment, we revised the Electoral College. And so this in part grows out of the controversial election of 1800 between Thomas Jefferson and John Adams. And so after that, we decided there are certain tweaks we need to make to the Electoral College in order to recognize the fact that we're developing into a system that's going to have political parties. And so we tried to make the Electoral College better match a political system with the existence of political parties. And the 25th Amendment addressed the issues of presidential succession and disability. This was an amendment that people had been debating decades before, but finally it was the assassination of John F. Kennedy that really made us say, no, we have to focus on this. We have to focus on what happens when a president's assassinated. We also have to focus on what happens when the president, for some reason, whether because of a medical disability or mental disability, actually can't fulfill the duties of president, even if they're alive. And so the 25th Amendment puts some of those processes in place.
And again, sometimes these things are like the urgencies of the moment and what's happening and happening, and they need to jump in and fix it. So I guess when we go back to this idea of, the big idea of the class, and that the founding generation put in a way to change the Constitution because, they knew that they weren't going to get everything right. When I think about that, it isn't because they're just like supremely like humble people, but it's also because they saw it not go well. And they were like, oh, no, let's not make that mistake. I don't want to be like, future generations look to us and say, why did you do that again? And I think, they learned that mistake by watching the Articles of Confederation. So let's go back to the founding generation and say, why did they put Article 5 in there in the first place? And what were some of the limits that were put into that originally in the structural constitution?
Absolutely. So, when the delegates, let's go back to the Constitutional Convention where they're meeting in Philadelphia and putting together Article 5, they're really trying to strike a balance between a constitution that's too easy to amend and one that's impossible to amend. And so when they're trying to come up with this structure, they want to create a process that's workable, that's clear, that's formal, that if the American people decide that they want to change their constitution, they're not going to need a constitutional revolution or to tear up the framework of government to change it. They could just use the Article 5 amendment process. And so when they're trying to figure out what should this rule look like, in part what they do is they look to their own lived experience. So this is a way many of them thought, which is that if we want to design a good government, we have to really look at some of the best thinkers of all time. So we look to political theory, but we also have to look at our own experience trying to create a new nation. And prior to the Constitutional Convention, prior to the US Constitution, we actually had a ton of experience in creating new constitutions and living under them. So between the Declaration of Independence and the US Constitution, we have the Articles of Confederation governing our nation at the national level. And then we have a series of 13 state constitutions that we created to govern each of the individual states. And both of these experiences inform what we do with Article 5. So with the Articles of Confederation, what the founding generation learns is that we actually need an amendment process that works. So the Articles of Confederation, it had an amendment process, but it required every single state to approve of any amendment. As a result, we never approved any amendments. The Articles of Confederation were never amended. And it's not because they were a great framework of government. The delegates really thought they were pretty lousy. The reason they were meeting in Philadelphia was to, at the very least, revise the Articles of Confederation. But in the end, they decided, no, we need to get rid of the Articles and create a new framework of government so they could feel the frustration of learning from the deficiencies of a particular system, but also not actually having a formal mechanism to change it as a practical matter. So with that, they wanted to make sure the Articles of Confederation were easier to amend than the Articles of Confederation. The other big thing, though, was that they looked to their state constitutions. And from that experience, they learned humility. It was this amazingly exciting moment for them. They saw themselves as the lawgivers. They were able to create their new constitutions. When we declared independence, Congress said states create new constitutions. And so many of these delegates to the conventions were political leaders in their own states crafting their state constitutions. But at the end of that period, as they're going towards the convention, they realized, man, we didn't do a great job with a lot of these state constitutions. There were a lot of problems with them. And so with that, they learned a certain amount of constitutional humility. That they really, not only it's not just a mantra that they didn't believe they had a monopoly on constitutional wisdom, they felt it deeply. They thought, we're really bright people, and we got some of these constitutions wrong. These constitutions don't have enough, we didn't build enough key principles like separation of powers and checks and balances in them. We didn't really create strong enough executives in some places. We didn't create an independent enough judiciary in others. And so what they wanted to do is they wanted to make sure, as they're creating this new US Constitution for the entire nation, to make sure that as over time we learn that there are certain parts of that Constitution that could work better, that the American people have an actual system for amending it, that we won't be stuck with a lousy Constitution.
And I think that is like an unbelievable important point, that they were looking at not only their successes, but their failures. And that giving them the wherewithal of saying like, well, maybe we're not going to get it perfectly right, So we should give an escape clause or a change clause. I also think it's really interesting how they look at the states and begin to see this idea that the states can experiment and what can we learn from that? Because we're going to hear that a little bit later when we get to other amendments. But a part of this process is let the states experiment with something that may work on a national level and see what happens. And then what's the right point to raise it to a national level and a national standard. But this question of change wasn't, I always think about this. I always think about they get to the end of the convention. They've been in sweaty, smelly Philadelphia, and I can say that because I'm in Philly, sweaty, smelly Philadelphia from, early May, some of them, all the way through to September. And they are already talking about, once they get this constitution out, what do we have to change? And I love Mason to death, but Mason's like, maybe we can fix it before we even get it out there. And he goes, bottom of the ninth, let's add a Bill of Rights. Let's add a lifting or a writ of rights to this constitution. And they're like, time out. No, we're done. We want to go home. But so quickly, almost their first charge is to change the constitution. How does that play out in the narrative that here's this new governing document, and by the way, we're going to change it pretty quickly? How does that play out in the narrative of ratification of the new constitution and the belief that this document is solid but flexible?
Yeah, it's a great question, Curry. It's a really tricky balance to strike. And so, we begin with George Mason. It's the closing of the convention. He's looking at the document. He says, no, I really think we should add a Bill of Rights. The delegates say, no way, we're getting out of here. And so the delegates end up approving of a constitution without a Bill of Rights. George Mason then becomes one of the dissenters. He decides not to sign the Constitution. And so this debate over a Bill of Rights becomes part of the ratification debates over the Constitution. And so remember, at the end of the convention, the delegates are sending this Constitution out as a proposal to the states to say yes or no. It's not the Constitution yet. Only if the states vote to ratify will it become the Constitution of the United States. And in these ratification debates, they're state by state debates. The anti-federalists, those who oppose the Constitution, echo Mason's calls. And they say, why in the world would you create this powerful new national government and not write in it a certain Declaration of Rights limiting the powers of the national government and also protecting some of our most cherished liberties? And so over time, we eventually decide to ratify the Constitution. It's really close in some states, including George Mason's home state of Virginia, but also Massachusetts and New York. And so it really was close. The American people saying no to the new Constitution. Ultimately, they say yes. The Constitution's ratified. The first Congress meets. The first Congress is actually, it's an overwhelmingly Federalist majority. It's the supporters of the Constitution that are elected to the U.S. House, the U.S. Senate. A lot of them aren't enthusiastic about a new Bill of Rights. They're saying we have to build a new government. We need to create the branches of government, the judiciary, all of these things. We have to figure out how this Constitution is going to work. But in the end, it ends up being James Madison taking the lead in that first Congress. He was someone who was skeptical of a Bill of Rights to begin with. But what Madison's role here teaches us are really two big things. One of them is that sometimes the process of constitutional debate itself can expose certain weaknesses in the Constitution and suggest certain reforms that can make it stronger. And so Madison was never totally convinced the Bill of Rights was the most important thing in the world, but he was convinced enough there were ways in which we could make the Constitution better. So in that sense, he was honoring many of the points that were made by his political opponents. The other one, though, is that what Madison also understood was that the Bill of Rights was also about the larger American constitutional project. And so part of that project, part of what we want to do is that we know we just had this difficult battle over the ratification of the Constitution. Many people are disappointed and angry that they lost. The anti-federalists, some of them, they may worry that they may take their opposition outside of the bounds of our Constitution. And what Madison wanted to do with the Bill of Rights was to say, we hear you. We, the Federalists, may have won the ratification debates. We may have won power in the presidency, the U.S. House and the U.S. Senate, but we heard your good ideas. We're going to write them into the Constitution. And through that, hopefully you can continue to oppose many of our ideas because we believe in dissent in America. We hope that you see enough that the process is fair, that there's room for you here and you can debate within this constitutional system, not outside of it. And so the Bill of Rights ends up being about that creation of a structure that a broad range of Americans of different ideas could exist under, live under, debate under, govern under, but also with that one of the core principles or core ideas of the American project is that we're going to experiment, we're going to reform, we're going to try to learn how to do better the next time. And Article 5 is all about that. With the Bill of Rights, we end up with so many of the things we cherish most about the Constitution: the protection of free speech, a free press, religious freedom, jury rights. It's all there, part of the amendment process, as one of the first acts that we did, both as a Congress, but then as we as a people.
Awesome, Tom. That was fantastic. Love it. Now, real quick, and then I want to jump to a couple stories that we love. There are two limits put into Article 5 that limits, you can't just amend everything. So one of our students asked, you can amend the amendment process, right? And I love that question. It kind of goes back to what you proposed for the 28th Amendment, a way to make it maybe a little bit easier in the process. But there's two parts of it that you cannot amend. So real quickly, just check through these two, and then I want to go to two different stories about how the amendment actually got passed.
Absolutely. So yeah, there are two big exceptions in Article 5. One is that Article 5 protects equal representation in the Senate. So every state, no matter if it has a big population or a small population, gets 2 senators. The language here in Article 5 is that no state without its consent shall be deprived of its equal suffrage in the Senate. So in that sense, it just locks the Senate in place as basically being based on equal representation. The other is actually an unamendable part of the Constitution, which is that in the Constitution, in Article 1, Section 9, we protect the Atlantic slave trade until 1808. We say Congress doesn't have the power to abolish the Atlantic slave trade until 1808. Well, in Article 5 itself, it then says you cannot amend that provision. It's language that is impossible to understand unless you know what it's talking about, but it says no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article. So if you wonder what in the world those words are about, it's about protecting the Atlantic slave trade clause.
Awesome. That is really helpful. And we're getting some good questions. So we're going to have a lot of questions at the end of this class. I'm just warning you now, Tom. So two great stories around the amendment process. I'd love, and a couple amendments are in here. I'd love to talk real quickly about the 18th and 21st Amendment. And if you feel the need to sneak in the 19th in there, go for it. But I think it's kind of interesting to dive into these two amendments and tee up almost our Friday scholar who's going to only talk about the 18th and 21st Amendment, Dan Okrent, who wrote The Last Call, which is a book all about prohibition. But tell us a little about these two amendments because they use different parts of the process.
Yeah, absolutely. So this is the 18th and 21st Amendment, the Prohibition Amendment, and then the amendment repealing prohibition. So in part, this story is about, one of the lessons is that we as Americans, sometimes we reform the Constitution and then we conclude that we made a mistake. And so with the 18th Amendment said it banned the, quote, manufacture, sale, or transportation of intoxicating liquors. It was ratified in 1919. And so while it's easy to criticize prohibition today, one thing to realize about it is it was really responding to a genuine social problem. Americans drank a ton. They drank a ton of alcohol, and this leads to social problems like lost wages at the saloon, abuse at home, difficulty holding down a job, broken families, you name it. And so there was a long, decades upon decades, the temperance movement was battling against alcohol and its evils in American society. The 18th Amendment grows out of a bunch of different social movements, going back to our mechanism from the early part of the lesson, grew out of the progressives, the suffragists, the populists, the nativists, a bunch of white Southerners. So they all came together, supported prohibition, in part for noble reasons. So part of it was to try to make society better by taking alcohol away and eliminating some of those problems I talked about. Some of it, though, was a response to really nasty things, like bigotry against African Americans, bigotry against immigrants, especially Irish Catholics, bigotry against beer selling and beer drinking Germans during World War I. And so all of this ends up coming together to create the 18th Amendment. The 18th Amendment is part of this amazing period of constitutional reform, Curry, where we end up amending the Constitution 4 different times in a 7-year span. The 16th Amendment gives Congress the power to pass an income tax. The 17th Amendment provides for the direct election of senators. The 18th Amendment gives us the repeal of prohibition. And then the 19th Amendment brings with it women's suffrage. So it's during the progressive era, it's this period of great constitutional reform. But in the end, we decide we like some of those ideas, prohibition, not so much. And so with the 21st Amendment, we repeal the 18th Amendment. It's the only amendment that just in the text itself says exactly what it's doing, and it's repealing a different amendment. It says the 18th article of amendment to the United States, the Constitution of the United States is hereby repealed. So it's really, really direct. So this amendment's ratified in 1933. So, I mean, that's not a lot of time between the 18th and 21st Amendment. And in the end, it's really because the American people soured on the idea of prohibition. In part, they wanted free access, they wanted ready access to alcohol. But part of it, too, is that prohibition proved really hard to enforce. And so we saw a rise of organized crime, saw a rise of just people flagrantly breaking the law to get access to alcohol. And we, as the American people, we decided, this really flouts the rule of law and really deep constitutional values, and it's a bad idea. So we decided to repeal it. One interesting quirk of this process, Curry, is that the 21st Amendment is the only amendment that's ratified through specially called state ratifying conventions. So remember, through ratification, they could either be ratified through state legislatures or state ratifying conventions. Here Congress chose state ratifying conventions. The reason why was because Congress had the sense that, broadly speaking, the American people no longer supported prohibition, but they feared that within the state legislatures, there were still strong lobbyists for temperance and prohibition. And so what they wanted to do was create a ratification process that was even more closely connected to the American people, these specially called ratifying conventions, than the state legislatures.
Thank you, Tom. I mean, that's a fantastic story. And what I actually think is unbelievably interesting about this process, I love that you connected it with all those other amendments and all these big changes, these big social changes going on at the time. The thing that I think is so interesting is even after the 21st Amendment, they did research and looked at Americans before the 18th Amendment and after the 21st Amendment, and we had far less of these societal issues from alcohol. So the liver disease went down, all of these outside things, they were reduced because of prohibition and did not come back to the previous levels. So there was a long-term impact of prohibition, and very interesting kind of time period and story that we'll dive into more deeply on Friday. Now, we have about 8 million other stories, and we're not going to be able to get to them all today. So what I'm going to do now is I'm going to pause everything, but students, stay if you have questions, and we'll tick through your questions with Tom. There's just so many amendments, so much fun. And I will note that we will dive into each grouping of these amendments in more detail in the months to come in classes. In February, we're doing all of the First Amendment. We'll do the voting rights amendments. We'll also do 27 amendments in 27 minutes, which is pretty much our favorite class, but you will go through every single one of them. So with that, I'm going to stop recording